Mr. Brooks, could you please call roll?
For the State Treasurer, Mr. Juarez.
He's here, I'm sorry.
Mr. Rosensteel.
Here.
Ms. Higa.
Here.
Ms. Yamamoto.
Here.
Ms. Vargas. For the Director of Finance, Ms. Wong Hernandez. Ms. Paquin, you have quorum.
Thank you very much. We have a second item, approval of the minutes. Approval of the committee agenda on item 1. Do we have a motion?
I'll move.
A second? And how would you like to vote?
Aye.
Thank you.
No, that's aye.
Okay.
Is aye.
Thank you. So item 2 is approval of minutes of the February 7th, 2018 Board Governance Committee open session. Do I have a motion to approve?
Second.
And the vote?
Aye.
Aye.
Thank you. And item 3 is a Board Education Forum on insider trading. I'm very pleased to welcome Mr. Cleese on this important topic. And I'd like to turn it over to Mr. Bartow to introduce our speaker and the presentation.
Good morning, and as Ed takes his seat before you, I'll give you a little bit of background, although I'm not necessarily sure I can really do right by all of his accomplishments. But Ed is a partner with Hirschler and Fleischer. He is a member of the firm's investment management practice group. He has more than 20 years' experience in investment management, regulatory oversight, risk management. He is the chair of the American Bar Association's Institutional Investors Committee, and that's how Ed and I got to know each other on a panel on foreign securities litigation. Ed is author of How Safe Are Institutional Assets in a Custodial Bank's Insolvency, which might make for another topic that you might want to hear about. He's also co-author with the Nobel Prize winner of a treatise called Connecting with Companies, A Guide to Biomedical Consulting Agreements. In his spare time, Ed is a member of the working group for the Institutional Limited Partners Association, where he worked on first the model subscription agreement, and now he's working on the model limited partnership agreement. As he just explained to me, he's working on the duty of care section, so good luck to him on that. So I've asked Ed to come here today to talk about insider trading. He recognizes that there are varying levels of familiarity with the subject on the board, and so I've asked him to kind of walk us through that. He has quite a lot of slides, but if you notice, many of them are pictures. So I think he'll be very quick and interesting. And with that high bar, Ed, I'll turn it over to you.
Yes.
All right, I'm low tech. Yeah, there we go. Thanks so much, Brian. And I've really enjoyed working with Brian on the ABA and other events, and I'm really glad to be here today. We're going to talk about elements of insider trading. Originally, I was going to call it Insider Trading 101, but then I thought that might be viewed as a pro or con, you know, like here's how to do it. That's not what we're talking about here today. No, this is elements of insider trading. We're going to talk about the elements of insider trading. We're going to talk about a few cases, and then we're going to talk about policies and procedures. And I think the last part, especially from what I understand from yesterday afternoon, might be most of interest to you all. So hopefully I can go through these slides very quickly. But by all means, if you would like me to slow down or you want to talk about something, we certainly can do that. We've had a couple different versions of the slides. It's all been my fault. So hopefully the slides that you see on the screen are correct. If not, I will try to correct a few minor glitches that appeared in them. So this is really your session with that introduction. What I want to talk about this morning, the quick takeaways, what things that you might remember from this session most. The wedge that I try to introduce here in the agenda is to talk about the human side of insider trading, just to make it a little bit more interesting than maybe other legal issues that can tend to be rather dry. Then the elements, and then talk about guarding the institution. As I said earlier, probably the thing that is most interest to all of you. quick, Brian already told you about me. The one thing I want to mention is, I'm from a family of many public school teachers. My mom, my sister, who's retiring next month from the New York State, and she's covered by New York State teachers, so kudos to them. My aunt and uncle and a sister-in-law who's actually a Cal-STRS participant, and another sister is a public plan actuary, so of course the natural question is, where did I go wrong? Anyway, that's enough about me. The quick takeaways, again, I want to do this quickly to give you as much time as possible to talk about the things most of interest to you, is if you don't remember anything else from the session this morning, CalSTRS policy is all you need to look at. It's very well done. I had nothing to do with it. I'm not a paid endorser. It's very good, and it'll explain the elements of insider trading and all the stuff we're going to talk about today. It's you can rely on that to give you guidance. The second thing I want to say about insider trading is that the government will find you out. There is, ever since 2009, in a very well-known case involving a hedge fund called Galleon and their principal officer named Raj Rajaratnam, we have seen that the U.S. government will use what historically was regarded as procedures and activities that were more aligned with with crime, with organized crime prosecution than insider trading. Wiretaps, flipping witnesses, going into the data and finding all the incriminating emails and trades. They will find that. This third thing I want to mention as a quick takeaway is that the law is in the eye of the beholder. What do I mean by that? Well, the underlying statute that people rely on is the anti-fraud provision of the 1934 Securities Exchange Act. That act doesn't say anything about insider trading. Not until 1961, I believe, was there the first, and then only in an administrative case involving insider trading. Since then, insider trading is really a matter of courts deciding what the law is, not Congress and the president telling us what the law is. What does that mean? It means that prosecutors, the SEC, the Justice Department, have more ambit to take positions that are perhaps more aggressive than the underlying law can support. And what does that mean? It means that people can get tied up in an insider trading web without really even understanding that they may be exposed. The next point is that institutional oversight is key. When we have any kind of institution, including this organization that has an investment office, it's especially important. And the last point is winning is losing. What I mean by that is that because the stakes are so high when somebody is charged with insider trading, that even if they succeed in defeating the allegations against them and are exonerated in court, they will have lost their job in all likelihood. They will not be covered by their employer's insurance or indemnification policies. If they're in the investment business, they're probably not going to be back in the investment business for the rest of their careers, or they're going to have to really move back and start all over again. And the reputational damage to them personally can be extreme. Those are the quick takeaways. We're going to run through the rest of the slides as quickly as you would like, but those are the things that hopefully we can cover in more specific examples as we go through. This board policy from CalSTRS is really the core of the policy, or at least it's the core in terms of defining what insider trading is. It's from policy 600B. What I want to point out to you, though, is that these are all legal terms, and by legal, what I mean is judicially determined terms. None come out of the code, the U.S. Code. Insider trading, as I mentioned, is not part of the underlying 1934 Securities Exchange Act. On the basis of, there's reams of cases deciding what that means. Material, non-public, possession, insider, controlling person, tippee, tipper, fiduciary duty, misappropriated. These are all judicially prescribed terms. And depending on what district you're sitting in the United States federal court system, different local districts take different positions. And, as I said earlier, the SEC and the DOJ are not shy from taking expansive definitions when they believe that there is unfair trading. Eye of the beholder, the Securities and Exchange Commission. As I mentioned, in the last 10 years, they are employing what had been considered maybe organized crime prosecution tactics to uncover insider trading, including the use of algorithms, especially the use of algorithms, where basically by running algorithms, names pop up, trades pop up, and they can reverse engineer and reverse analyze to figure out what's going on. We might, I asked myself, like, since the new administration, the new presidential administration, is this still a priority of the SEC? Under the Obama administration, it was a very prime target, especially with the view, I think, that some would say of the Obama Justice Department, that hedge funds were trading, running amok, one might categorize, with respect to insider trading, or at least that was the belief. Well, look at these figures. This comes from late last fall, the SEC's annual report. If you look at the fifth bar down, set of bars, insider trading prosecutions are still significant, slightly down from the year before, but they've not gone away. I think that unless and until we hear something new from the Department of Justice, we should assume that the policies and procedures of prior presidential administrations and prior attorneys general will persist. We talked about the stakes. The reputational risk is not just that of the individual, it's even more so of their employer, especially when we're talking about people from the nonprofit or pension plan sector. Obviously, the institutions that manage money, the Wall Street banks, they have reputational risk, but it's manifestly different because I think we've all maybe become a little bit immune to the fact that there are these allegations that come out with some frequency from Wall Street. It's much harder for somebody who's on the investor side to recover from the reputational risk at hand when somebody in their employment may commit insider trading. The sanctions, I don't think we need to spend much time on it. Clearly, there are significant sanctions. Disgorgement of your profits, penalties, significant in penalties, losing the ability to work in the financial industry. On the criminal side, prison. Raj Rajaratnam, the man I mentioned recently a few minutes ago, 12 years in jail, 11 years in jail, significant fines. I mentioned the eye of the beholder. It's also the eye in the sky. Whoever's trading in the U.S. securities markets, whether they know it or not, maybe isn't necessarily being watched, but their trades can be tracked. And as we've discussed, there are many different ways for the Department of Justice and the SEC to discover insider trading, including the elements mentioned here on this slide. What the SEC has done in the last decade is basically work of the domino theory, which is to find through algorithms a group of people who have traded at the same time and through whom there is some relationship that they can decipher, and then work up the pyramid to get the biggest player in the group. Sort of like organized crime enforcement, what you talked about. This is one example of one case, but what I like to point out to you is if you look down to the third level at individual X and individual C, this individual X made $609 from their trades, and they were prosecuted. Individual C, $6,000, they were prosecuted. We think of organized crime as being, a deep pocket or, high roller kind of crime. That's not the way prosecutors regard it. If they find you in the web, you have some explaining to do. That case of Raj Rajaratnam, you can see here, although it's a little murky, it's not necessary to see the actual words. You can see how the government found players on the periphery, either wiretapped them or looked at their email or did other things in addition to that, flipped them as witnesses to go after the big player in the middle. Another example of this and how they achieved their success in convicting Raj Rajaratnam. He's, I think, the name and face that people who practice in this area are most familiar with, because before Mr. Rajaratnam and before Galleon Capital, Insider trading was an episodic matter that was usually proved by the luck of information falling into the hands of prosecutors more than using the enforcement tactics that we're familiar with with organized crime. Since Rajaratnam, everything has changed, and perhaps it had changed before that, but we only became aware of it with him. We know lots of different stories about insider trading. Phil Mickelson last year was almost charged with insider trading. The man behind the bars is the person who gave him a tip on trading in the stock of, I believe it was Dean Food. And his name, I think, is Billy, I forget his last name. There's maybe somebody here remembers. Yeah. Billy, Big Sports Better. He got the tip from the CEO, I believe, of Dean. And he told Phil Mickelson, in part, as I was reading last night, I didn't know the details, but Phil owed Billy a lot of money on sports bets. So here was a way for Billy to help get repaid and do a favor for a friend. He was not charged. Mickelson was not charged. Billy was convicted. He was not charged because the government was not certain that they could prove that he knew that this was inside information, that this information came from a person who had a duty either to the issuer of the securities or to the person who had engaged them. And we'll talk more about what that all means. But he succeeded in not getting charged, although I guess the statute of limitations has not gone out, and perhaps there could be some further development. This March, the CEO of Equifax learned that they had been hacked about a week before the information became public. He traded in the security of Equifax, made $1 million. He was charged. People do everything. What's really interesting about insider trading cases, if you look up, do a Google of crazy inside trading or funny inside trading, you'll learn everything about the way human beings behave. This individual here, that's not him, but that's a picture I got from the internet. He would get tips from a person at a Simpson Thacher law firm about pending transactions. And then he would meet under the clock at Grand Central Station with a trader. And he would bring with him a piece of paper with the name of the securities, like the initials, APL for Apple, for example. He would show it to his friend, the trader, and then they have it on video, him putting it in his mouth and chewing it and swallowing this, is like cloak and dagger. Well, anyway, that didn't take them that was interesting information to any jury. So there was no question about the belief in liability. This is one last case, is a group of people who worked in a railroad yard in Florida. The Steffs, there were a bunch of related people. They noticed that there were groups of people walking around the rail yard in business suits once or twice. There were a couple of other, one of them was asked for, like an inventory of rail cars. And through incidental exposure to those kinds of little events, they concluded on their own that the company was for sale. They didn't, one of these people was a mid-level manager. The rest of them were just rank and file employees. They traded on the hunch that the company indeed was for sale. They were correct. And then they were charged with insider trading, and they went to trial in 2014. Anybody want to guess what the result was? Did you think that they were convicted or whether they were not convicted? You are correct, sir. They were found not guilty. But here's a perfect example of why when you win, you lose in insider trading. They won, but they lost their jobs. They generally weren't high enough the ladder to be indemnified or covered by insurance. And now they have that on their records. Will they be able to find other jobs? I hope for their cases that they have. But this is an example of why the stakes are very high in insider trading. And some might say that in a way, even though the American justice system is that one is innocent until proven guilty, this is a situation where even merely the charge can be deleterious to the individual. Rajat Gupta, I'll move forward faster. He's a very interesting guy because he was one of the three leaders of McKinsey. and he traded on insider information, gave insider information to Raj Rajaratnam. Why do people like that do that? He had $84 million in net worth. He was on the boards of Goldman Sachs and Procter & Gamble and American Airlines. It's fascinating. You know, one of his co-conspirators this past Sunday, you know, offered some thoughts on the psychology of this, that people are more easily persuaded if they're meant to feel powerful, wanted, and included in the upper echelons of financial society. We don't know. And it's fascinating to wonder why. Let's move on, though, to talk about insider trading and what the rules are. As I mentioned, Securities Act 10B and Rule 10b-5, I think that's Securities Exchange Act, actually, prohibit conduct that could operate as a fraud or deceit. That's where all this comes from. And as I mentioned earlier, there's nothing about insider trading in that statute. The elements are purchase or sale of security while aware of material non-public information, in breach of a duty. We will talk about that in a minute, with intent to defraud or recklessness. Awareness comes from an SEC rule that if you intend to trade or if you possess, you pretty much are aware. You would be very hard pressed to prove that you weren't aware of inside information if you were charged with it. Materiality is another element. Would a reasonable person consider it important? This is very much hindsight, 2020 hindsight, Monday morning quarterbacking. If one is at all in doubt, it is very advisable not to trade. Because again, the DOJ, the SEC can decide whether they think it's material, even if you think it wasn't. What is non-public? That is not so self-evident. One could be attending a conference, an industry conference, hedge fund conference, for example, and somebody from a company speaks about their performance. Is that public disclosure? Well, maybe, maybe not. Not necessarily. The precept is that there must be sufficient passage of time for the market to absorb the information. In that case, it may not be necessarily true that that is a public disclosure. Then there's a duty. Basically, I think we could say that the government, the SEC and the Justice Department, I think view that anytime there is unfairness in the market, that is insider trading. When an insider or a temporary insider or somebody who has access to inside information trades on it or shares with it, that's always insider trading. But that's not necessarily the law. There has to be a duty breached. And the courts have fashioned some rules to find a duty even when it's maybe not necessarily the case. But basically, you have a duty if you are an insider. You have a duty if you misappropriate information when you have a duty to the person who provided you that information. What is an insider? Director, officer, 10% stockholder, anyone who has signed an NDA with the company, or company has signed an NDA with the company, anyone who has a high degree of access. Probably a low-level employee would not be an insider. We talked about the folks in the rail yard. There are also constructive or temporary insiders, lawyers. So, for example, we talked about the Grand Central Station person who swallowed the evidence. He got his information from a person at a law firm. Accountants, others with temporary fiduciary status. Those are real classic, I guess you would say, insiders. Then there's another theory of insider trading that looks at people who misappropriate information. So, for example, a non-insider who gets the information from an insider or who has access to information and trades in violation of a duty of trust or confidence owed either to the company or to the source of the information. So I don't want to spend a lot of time on this because it's complicated and the law keeps changing. In fact, in New York, there was a case a couple years ago that set a wider bar, and then the Supreme Court last year narrowed that bar. But basically, if somebody believes that the person tipping to that person the information may have received that information from the company or from some other source close to the company, you risk a misappropriation claim. this is what you may have heard as tipper-tippee cases, where a person tips other people. Either he or she tips family members or friends, or they tip other people for some kind of personal benefit. And then liability likely will ensue. The real question is what happens to what are called remote tippees, somebody who is 2 or 3 or 4 degrees away from the original tippee, such as Phil Mickelson. That is a case where Phil Mickelson is a remote tippee, and the question is, that the prosecutors would have considered was, did he have enough awareness to know where this information ultimately was sourced? Front running is another illegal activity. Sometimes it is the same thing as insider trading in the sense that the person who trades has gotten the information from an inside source. And they trade. Front running basically means that you are trading before your client or the person to whom you owe duty. Historically, it applies to brokers and other people on Wall Street. They hear, for example, that Warren Buffett is going to buy Goldman Sachs in 5 days, and they buy Goldman Sachs today. That is classic front running. But it can apply to other people in the market, and it can apply to individuals. So for example, if an employee of a firm learns that that firm is going to be trading, and that employee trades for their personal account, that sounds to me like that is front running. Now, the key question with front running is, are you trading in front of somebody else, or are you trading or is it your information? The question becomes, whose information is this? So for example, not to get into too fine a point, but let's say that a university investment office is talking to one of their third-party fund managers, and the fund manager says, we really love Apple, and here's why, and here's all this information. And that university investment office goes off and buys Apple, or sells Apple, depending on what the information was. Is that front running? Well, again, it becomes a technical question because you can't, the belief is, and this hasn't been litigated, but the general view is you can't front run yourself. I was thinking this morning of, could you front run yourself? And I thought of some examples. I won't bore you with that unless you're interested. Generally speaking, it would be hard to prove that one is committed front-running violation by front-running oneself. The question is that information from your third-party manager your information, or is that information their information? And in some cases, it's probably more likely that it's your information, depending on how the account is set up. But in other cases, it's probably their information. That can be dealt with by contract ahead of time. You could say, anything you tell us, we might trade on. And then you're probably in a much better position to trade. But none of this is necessarily black and white. And again, ultimately, you have the Monday morning quarterback of the DOJ or the SEC deciding what the rules are when you traded, or if when you traded in one direction or the other. I've gotten through the elements of insider trading in some examples. I'm not keeping track of my time, but are there any questions about any of that? Because I would like to now turn to probably what's more interesting to all of you, or more tactile, which is discussion of trading and culture within a firm.
And Mr. Cleese, just for a time check, you have about 15 or 20 minutes.
Okay. All right. So thank you. So what I'm going to do is talk about.
Excuse me, Mr. Cleese, we have one question before you move on.
Oh, sure.
Ms. Hendricks?
I just had a question about. It just seems, this is just an interesting topic, just because reading the paper, there's lots of interesting stories, but I always wondered, for people in our position where you're a trustee of a large pension fund, and we often say, we are the market. We have so much in so many places. And I honestly have thought to myself, well, what if, one day as I'm working through my finances, you say, oh, I want to work on, more retirement savings, and so I decide to buy Apple or something. And we have, clearly, I think that's one of our top 10 holdings is an Apple. And so I wonder how you think about, or how you would advise, trustees on pension funds like ours that are passively invested and kind of everywhere in the market. How do you approach? I mean, is it best just to kind of keep my Vanguard index fund that I had since I was 22 kind of thing? Or how do you advise trustees on that investing question?
Oh, thank you, Ms. Hendricks. That's a great question, and it's a very hard question.
After your talk, I was like, it seems impossible.
Yeah, and we're going to, actually, it's like,
It seems impossible.
we're going to talk about this is going to be the last slide, actually.
Okay.
But basically, the question is, to my mind, the risk is that when the SEC and the DOJ do their algorithms and do all of their, data and other analysis, it is impossible from a third-party perspective to know whether you are an innocent bystander or whether you're not an innocent bystander. They can't tell. And then the question becomes, who are you? And what is your connection to the stock that was traded? And the more linkages that, by the way, this is all, shadow boxing. I don't profess to have the answer. But my concern personally, I do not trade in personally, I don't trade in individual stocks. And the risk is, to me, let's look at an investment. My experience is mainly working with universities and foundations and other public pension plans and their investment offices. And I've done compliance. I've sat at the compliance desk, and I'll give you a real life case study. A junior analyst sat in on a meeting with a hedge fund, and at that meeting they discussed, I call it the case of the frontier umbrella manufacturer. So let's just say it's a company based in Malaysia, it doesn't matter, an emerging market company that manufactures, let's say, umbrellas. I was reviewing the brokerage statements for his account a month later. And there are trades for that stock. And I reported it to the chief investment officer. And he said, find out what's going on here. And so I spoke to this junior analyst. And he said, oh yeah, I was at that meeting, but that had very little to do with my decision. I had been analyzing this company for a while. I've been reading this report and that report. And there's this theory of defensive insider trading called the mosaic theory, which is that basically, oh yeah, maybe that was that part that I got from the insider was one, one cell, one tile, but the rest of the mosaic was all my work. And
Umbrella manufacturers in Malaysia.
yeah.
It's very common.
All right. So the bottom line was there never was any insider trading case, but as an employer, we didn't like him in this case doing that. And we said, don't do that. And so some people will decide for their institution not to permit the investment team to trade for their personal account, or they might require that you submit your trading statements to somebody like me. And we are monitoring not only legal compliance, but I had one other case where somebody had like 200 trades one month. And that was a legal violation, but it was like, hey, what are you doing all day? We want you to do your job. Clearly. So there are a lot of different elements at play. Or you might say, Apple is a good example, because you might say, well, you can trade in the S&P 500 because we are taking the calculated risk that you're not going to move the market. But we don't want you trading in Malaysian umbrella manufacturers because that's a different story. And by the way, I'm not recommending one approach for the other to all of you. I'm just sharing with you my experience and that there are different approaches. So that's a great segue. Thank you. That'll lead us right to the elements of looking at a trading program. These are all obvious to you. You probably talked a lot about this yesterday. I know you talked about this general topic, but I think the point I want to make most about the elements of a good insider trading policy or procedure is top-down leadership. Without that, it's never going to, no matter who the employer is, it's not going to succeed, or we may not succeed with the kind of rigor and success that you would want to see it have. Some of you are old enough to remember this show, Get Smart, The Cone of Silence, but if there's one rule that one shares with employees is, like what you learn here stays here. And you don't take it with you. You don't use it for your own benefit. It stays here. The information you learn here belongs to your employer. It does not belong to you. We were talking a minute ago about different ways to regulate personal trading by an internal investment team. One is just to permit it. And you have your policy. Do not trade on insider trading. Do not front run. Do not violate the law. If you have any doubt, step out. You know, all the other little funny phrases. That's all fine. That might be the appropriate approach for a particular office, for a particular firm, for a particular employer. The positives are that it helps with recruiting. Needless to say, a lot of top talent that comes out of, that goes into institutional investment is tempted to make a lot of money on Wall Street. And so sometimes, it's harder to recruit if you're not on Wall Street, but you do have a professional investment practice. It allows people to develop their skills as investors. And, it's, as an employer, one I think is always a little bit reluctant to try to impinge on people's personal freedom. The cons are that there are legal and reputational risks. You lack oversight. You don't necessarily know what they're doing. And, as in the case I just mentioned of the Malaysian umbrella manufacturer, I have, in my experience, have found that for junior investment professionals, the learning curve on some of this is not as steep and immediate as one would hope. There's another option. One could require personal trading reporting, self-reporting or attestation, so that you have your policies. You're not supposed to trade on insider information. If in doubt, step out. But also, we want you to tell us what you're doing. The benefits of that is that it doesn't require much time and effort, either of the employee or of the compliance staff. This assumes, I'm sorry for the second bullet, because if you read it, you would have no idea what I'm saying. But what I meant to say there in the second bullet is it assumes that the employer has no greater legal obligation than that. And if you're a registered investment advisor, you would. I know that this is not the case here or with most institutional investors, but there may be a California statute or other regulation I'm not aware of that may impose something more more proactive than that. Those are the pros. The cons are, again, risk of non-reporting. This is all, on the honor basis. People, I think, I have no doubt that people mean well, but sometimes people forget. Even, and I've seen that. People honestly forget. Then you also, again, lack the oversight, and you don't have as much ability to effectuate compliance. And again, the same point from last time, that junior people, and maybe even some more senior people, may find this a challenge. A third option is to require basically brokerage statements and pre-clearance of trades. You set up, within the compliance office, you set up a trading desk, and do you require people to send copies of their brokerage statements to that trading desk, or you can outsource it to a third-party compliance consultant. And they review those trades, and they review them against your policy, and they review them against your restricted list. What that means is that the investment team would develop a restricted list, and if, for example, using Ms. Hendricks' example, if, like, for example, you were, the investment team heard something very hot about Apple, they would notify the trading, they would notify the compliance desk to put Apple on as a blocked security for a certain amount of time. And then when people came to the trading desk or the compliance desk to ask for permission to trade, they would be told, you can't trade in Apple. You'll have to come back under the policy in a week, 2 weeks, whatever that is. This is better practice in terms of liability and risk, because you are proactively watching what they're doing and monitoring and precluding trades in particular stocks. It's also a lever for the chief investment officer. I gave you that example a minute ago. It's not necessarily any legal violation, but now hey, you're spending too much time trading. Get to work. It's better legal protection if you're not a registered investment advisor, and it's better reputational protection from people who are always looking over one's shoulder and ready to criticize anything that they hear. It requires more time. That's a big con. You will require, somebody more or less will be spending most of their day, if not all of their day, with this. And then actually these technical questions about who's covered by providing brokerage statements and who has to pre-clear trades. Is my spouse covered? I have a dividend reinvestment plan with AT&T. Does that count as trading? Are certain ETFs counted as individual stocks as opposed to mutual funds? That's probably going to be covered under your policy anyway, but these are technical questions. The fourth level is what many registered investment advisors provide, which is to simply bar personal trading. You can't trade for yourself, and your spouse can't trade, your minor children can't trade, anybody under your roof cannot trade. The only way that you can trade is by investing in our own proprietary funds and products. You invest with the firm and you ride with us side by side, but you're not trading for yourself. The firm gets copies of your brokerage statements. You can't use personal equipment for trading. They're restricted lists, they're pre-trade clearances. They monitor your email, and they have a CCO, and they audit compliance through an external consultant. The last thing I want to say, I know that I'm probably going too slow, and I apologize for that, but I want to allow time for some questions. Is within the investment group here under your roof, is how do they interact with either managers who have already been retained or other third parties you're thinking about working with? There are levels of interaction here too. Well, some principles that many people consider is not to sign a non-disclosure agreement with that third-party manager, especially a potential third-party manager, without going up the internal chain of command. Setting the stage before having any meeting or call about what we may use from this meeting and what we won't use, and what we might share with you and what you can use it for or not. Dealing with expert networks, I'll skip that. And then having compliance staff document all meetings that the investment team holds with third parties. To close up, just as a reminder, this isn't going away, at least so far. It's going to remain, at least for the near future, a major attention grabber of the SEC. And as we talked about earlier, this is when I was a chief compliance officer and when I looked at the trading desk, this was my greatest worry. The algorithm can't tell who's a co-conspirator, who's just trading in parallel. And then you work backwards from incriminating information. The more elements there are, like your employee is trading in a stock that also your hedge fund is trading, it becomes dicier and dicier. And then ultimately, even if the person is innocent, they have to disprove a negative. And when you think about that, that's a lot harder, right? How do you show you didn't know or that you didn't consider it to be important? I wouldn't like to see anybody in that position. It's a very worrisome position. To close up, the chances of you beating the algorithm, slim and none, and slim just left town. It really is. That's why I don't trade in individual stocks anymore. Anyway, that's it. My email and phone are on the last slide. If that's in your book, I'd be more than happy to answer your questions after the session. But hopefully I haven't blabbed on so long that you don't have some time now to talk about things that are of interest to you from yesterday or that I may have raised this morning that incite curiosity or comment.
Mr. Cleese, thank you. That was such a thought-provoking presentation. We do
thank
have
you.
a few questions. Ms. Hendricks?
First of all, there was a request for you to go back to that last slide
leave
from
the
my
greatest up there.
colleague.
Just
He
leave it up
wants
there
the
during
greatest
questions.
continuing to be up
Greatest of
there,
all time.
sitting above us.
Yeah, let's leave that on.
Football,
Yeah,
Muhammad Ali.
yeah, right.
I was just curious, I have a couple of friends that have worked with the SEC, and it seems like, from what I hear through the grapevine, just understaffed, underappreciated.
Right.
And I just wonder what your sense is of how much oversight is really happening, and, do you feel like this is an issue that's just kind of, running rampant and really the SEC can't quite keep up with the,
Well,
I'm thinking of like the kind of trading that people are doing now, the micro trade, just
right, the high frequency
flash trading,
trading.
speed
Yeah.
trading. And
Yeah, sure.
so it just seems like anyone and their mother with an iPhone, can just, so
Right.
I just wonder how
And-
you monitor that.
Right, and technology is going faster than any governmental agency or any humans could keep up with. Right now, they're worrying about Bitcoin. Is Bitcoin a security? How do we regulate Bitcoin? Do we regulate Bitcoin? I don't have any special knowledge about to what extent insider trading has either stayed at the same level as the past or is increasing or decreasing. I know that they still have funding for it, and I think that the reason historically that it became such a big issue with Rajaratnam in 2009 and subsequent is that I think there really was a sense in the government that hedge funds were running amok, and that they all knew each other, they were all, playing tennis together, and they were just batting it back and forth. I can't say whether that impression is still viewed, whether that's still a current opinion of the Commission or the Department of Justice. I don't know. I think, though, that the fact is that once you have an algorithm, and it takes a lot less effort to find really bad stuff. And I think as long as there are ways to commit fraud, people will find ways to commit fraud. And even despite this slide, I think that we talked about some of those. We talked about Mr. Gupta, who is head of McKinsey, and he still shared inside information with his friend Raj Rajaratnam. Nobody in the business world would know more firsthand about the importance of insider trading. He still did it. So, we can talk about psychology, we could talk about greed. I don't have the answers.
I'm not going to get caught. I'm going to somehow game the system. And I do want to commend you on your PowerPoint presentation because I love the slides and the
great.
Get Smart reference. It was a little before my time, but I remember Agent 99. I thought that was great. So I commend
All right,
you.
well, we can all rely on remakes to keep things current. Yep, great.
Thank you. Mr. Rosensteel?
Great, thank you. This is
Thank you very much.
Very interesting. Am I on?
Let's see. For some reason it's not clicking
My
in.
mic is still on.
Can you announce it?
Oh, I'm sorry, I thought we were done.
I don't think the mic's are.
There it is.
There, okay, thank you.
Okay.
So I found it interesting, you're talking about the different levels of sort of the rules that an organization can adopt. And I was 30 years in the securities business and living under the second most restrictive. That is, we could trade, but there was enormous oversight, pre-approval, watch list, restricted list, all of that kind of stuff. And I think it's actually, while it seems excessive, I'll just say that it burns into your mind that there is an insider trading policy you have to think about. And that's the important thing, because you have to take several steps every time you want to make a trade. You can make a trade, but you have to think about that trade and know that even if the trade is fine and doesn't violate any insider trading rules, if you don't get it pre-approved, you could lose your job just because you violated the policies. So I think an organization that has a strong policy is very well served, even if it goes, a little bit beyond where the risks are. But the question I wanted to ask you is, and Sharon unfortunately just left because Sharon asked the question earlier that we're an organization that does just mostly, we own the market, we're passive investors. But I'd like you to comment for the purposes of the board, where you think the board might be in possession of material non-public information. We go into executive session. We have at every investment committee meeting, we have a topic. We don't say anything more than this to the public, but we announce that we have a tactical asset allocation discussion. Sometimes this board goes into executive session and makes a decision either on an investment or perhaps to sue a company. Where, under what circumstances should we be careful about the fact that we actually might be in possession of material non-public information as board members?
Well, thank you, Mr. Rosensteel. Great question. Yeah, it's in the time that I've spent advising boards and working with boards, there are actually two directions to think about. There's the direction you as a human being, the things that you do all day long, that either, for your full-time job or working in the securities industry, and that information, and then coming into this building, metaphorically sometimes speaking, but when you're putting on the hat of CalSTRS, that information can't be brought with you. And the cone of silence applies. So, and then there's the other direction, which is the information that you asked about, which is when you learn things here. Well, I think you would probably agree with me. There's probably no necessarily clear and singular answer to that question for all information. So information about a market, you're going to lower your allocation to public equities and raise it to alternative equity. That I think I'd feel fairly confident saying that probably is not information that is a piece of information about an issuer of a security. It applies to a whole sector of the market. On the other hand, if you've recommended bringing in a litigation securities class action against issuer X, to me, that I would probably advise that any individuals should probably not trade in that security while in possession of that information until it becomes public. I think that you have really great counsel here, and I think that your point is well taken about if to the extent that an employer can do a little more rather than a little less without affecting the infrastructure and to do it in a way that works organically within the firm, because if the policy and the procedure isn't going to work organically within the firm, it's not going to work. But if you can cohere it to what you want and what will succeed, and you can do a little bit more, that's better than not. I would agree with you there wholeheartedly. Thank you.
Thank you, Mr. Cleese. We have one more question. Before that, just as a quick follow-up. So would you recommend best practices would include the board and staff under the same personal trading policy?
I think any corporate representative who has access to inside information about issuers of public securities should be subject to a personal trading policy. What that policy says, you have one already. I think it's quite good. But I think that anyone who has access should be considered to fall within the parameters of a personal trading policy.
Okay, thank you.
Thank you.
Mr. Keeley?
Thanks, Lynn. Thanks for the thought-provoking presentation. I appreciate the last couple of questions as to what perhaps is actionable here for us. I can't help but think of like the average man or woman who decides they want to have like a concentrated portfolio in 5 positions that they really like, and they've got a little discretionary money and they're well-read, and they decide they're going to take a flyer on Kodak, right, cameras, versus folks who are setting up trading floors as close to the New York Stock Exchange as they possibly can,
Right.
with the greatest fiber optic cables
Right. Yes.
that are trading, and the impact that speed trading
Right.
and high frequency trading to essentially manipulate the market
Yes.
and to profit from that manipulation by their close proximity to the New York Stock Exchange or whatever exchange, and the use of technology and computers. And they're very different. Do you have a view on that whole topic of the role that technology and physical proximity to exchanges, is there any truth to that? Is it a myth? Is it something people have written books about just to make profits themselves? Or have people actually benefited at the expense of a fair market for the average trader out there?
Right. Thank you, Mr. Kiley. Yeah, those are 2 different situations. Let's be mindful, as I think your question implies, that just because there are rules against insider trading doesn't mean that other market manipulation is legal. There are lots of different rules that apply to different sectors of the trading world. And there are more rules that apply to registered investment advisors and brokers than there would necessarily to an unregistered institutional investor. I've read the same stories you've read. Apparently somebody paid millions and millions of dollars to build a special fiber optic cable from outside the New York Exchange to somewhere in Illinois where they can get a millisecond faster information for high-frequency trading. I can't speak specifically about that and whether it implicates a specific law or regulation affecting market manipulation, but the Supreme Court has been pushed by the SEC and the Department of Justice, at least in the insider trading world, to basically create a rule that any what they call asymmetrical information, trading on asymmetrical information is de facto insider trading and illegal. And the Supreme Court has never gone that far. They require access to inside information and then this breach of duty, which we talked about, which is a little bit vague, and that they've kind of shaped to fit fact. Well, I want to take that back. I don't want to get in trouble. They've shaped the duty to capture when something is inherently unfair as opposed to somebody where it's fraudulent, as opposed to somebody just having better information. So, everyone I think has heard of traders who go and count the amount of cars in Walmart every Saturday morning. They have people all over this country counting cars. And they count cars at Walmart, they count at Kmart, and then they work, they figure out, okay, this quarter is going to be better, it's going to be worse. That is part of traditional, shoe leather investing. I don't know if people actually do that or not, but that's the story you always hear. The Supreme Court has said asymmetrical information is okay. It's just how you got the asymmetrical information that's the problem. So, again, without being able to answer your specific question, my guess is that unless there's a specific regulation that is in place that says you can't set up shop, right across the street from the stock exchange to get an infinitesimally faster trading platform, I'm not sure that that's necessarily illegal. Is that helpful?
Yeah. The guy's name was Billy Waters in Vegas.
Waters.
Yeah.
Walters, yeah. Billy Walters, yes.
Yeah.
Yes, thank you.
Yeah.
Yeah.
He was probably the winningest sports bettor in Las Vegas history.
Yeah, the interesting thing about that case too is that Carl Icahn apparently was another
Icahn was
person.
involved as well,
And
yeah.
as you know, about a month ago, he was accused of trading in a steel company before the steel tariffs were announced. Anyway, it's really very interesting stuff. Any other questions?
I don't see anybody else in the queue, so thank you again, Mr.
Thank you
Cruz.
very
It was a
much.
great presentation.
Thank you.
Thank you.
Okay. So the next item is the committee work plan input for the next fiscal year. And does anybody on the committee have any additional items for this? And before we get to that, I just wanted to quickly go over the framework. We have the Board Education Forum, which we will continue to provide education and also work with other committee chairs on the framework of the education program. And then we have a line item for board accountability and compliance. And in talking a little bit more about this with staff, we're thinking that given all of the work that Ms. Mount has been doing on the enterprise-wide compliance, this item might be called something along the lines of board focus and accountability, something a little bit different to take that compliance piece out without losing the board accountability to ensure that policies and procedures are being adhered to. And then finally, we had the board policy manual revisions, which Ms. Lukens was planning to address.
Thank you, Madam Chair. So one of the policies is the 600H policy, and it's the campaign contributions and gifts disclosure from our vendors. So I think this year we'd like to look at some of the terms, tightening up the terms in that policy. There's certain terms such as any party that's not necessarily defined, makes it a little difficult sometimes for staff to interpret that to vendors and to apply the policy. So we're just looking at revising some of that language. And then in addition to that, there are three times during the year that a vendor will have to fill out the 600H and provide that. And one of them is at solicitation, which makes sense, so that we know if there's any conflicts of interest before we further engage in a contract with that vendor. And then at the time of contract, they also file a 600H, which also makes sense to make sure that when we are entering into a contract with a vendor, that there's been no pay-to-play going on there. And then there's a requirement that the vendor files annually thereafter. So we're going to take a look at that and see the practical application of that. There's some administrative issues with excuse me, with gathering those forms and applying that policy. But we just want to take a look and see if maybe there's redundancy as well, because board members, for instance, file Form 700s, and any gifts received would be disclosed there, so there might be some redundancy on that. And maybe revising the policy so that that term applies to maybe contract renewals or extensions rather than just filing annually. So there's that. In addition to that, we have discussed possibly looking at a board travel policy. Currently, our domestic travel policy and international travel policy applies to board members, but it might be a good idea to take a look at whether a specific policy to board members be added to the board policy manual, and then associated procedures with that, just to solidify that process for board members to make it easier to understand obligations with regard to travel.
Great, thank you. Any comments or questions on the work plan?
So do we
Ms.
have,
Yamamoto?
so do we currently have a board travel policy? We do, right? Okay.
Yes.
And what section is that?
Well, it's actually our CalSTRS policy.
Okay.
Yeah.
But not specific to board,
There's some general provisions.
so it's
Yes.
just general? Okay.
Absolutely.
Chuck will let you know, Karen. I've been trying to read it.
Mr. Warris?
Yes, thank you, Jill, for the presentation. Do we have a board education policy? We were talking about it this morning, and Nora and I were just going over. I know I have one at PERS. I'm not sure if we have one in terms of number of hours that we,
Yes.
and what qualifies.
Yes.
Maybe it would be helpful if we could get that list of what types of educational things, but in particular, things that we do here as a
Sure.
member of the board would be helpful.
Yes, we do have a board education policy. We revised it actually a couple years ago, I believe. And then there was a hour requirement that was added at that time. It's very consistent with the CalPERS board education policy as far as hours go.
Let me ask the question.
Yes.
Could I apply what I've done at CalPERS to
Yes.
presumably, yeah?
Yes, most of it. Our policy is very broadly worded to capture a variety of things that trustees receive education on, and there are many educational opportunities that you receive at CalPERS as a board member that would equally apply to our
Again, it
policy.
would just be helpful if you could disseminate what the current policy is, and I don't know if you can tell us what our status is relative to having met the requirements. That would be helpful too.
Sure.
Thank you.
Thank you. And then the other item, I'd like to direct council to pursue, if there's a committee agreement on this, is to start to look at bringing forward a personal trading policy, or starting work on that in coordination with the investment office. So that looks like something that we would want to pursue. That would be great. Okay. Thank you.
Can I?
Mr. Rosenstiel.
Yeah, I'm not, I mean, this committee deals with board governance, not governance of, I mean, it is, I think we need a policy that applies to the whole organization, right? So is your suggestion that we just get a policy back for the board? Or, I mean, I've always understood this committee's responsibility to deal with the governance of the board, as opposed to the governance of CalSTRS is the responsibility of the whole.
I think that what we would like
Retirement
is a policy that deals with the board, with our own personal responsibilities as far as personal trading, but also we do have the responsibility to oversee broad compliance on an enterprise-wide level. But I would imagine that the investment committee would be taking the lead on the actual implementation process. So in other words, the mechanics of what they need to do. And that's sort of something, an area that we also need to flesh out a little bit more because, you know, for instance, at CalPERS, the board members are also subject to the personal trading, pre-trade compliance, as Mr. Juarez was speaking about, and so on. But, you know, we don't have the same types of granular details that the investment and staff has as well. So I think this was just the start of a conversation to see how it would bring that policy forward and where would it be in the overall governance, board policy, and then also in investment policy. Is that correct, Mr. Roto?
Yeah, so historically, the insider trading policy is part of the board policy manual. And Mr. Rosenstiel will remember about 5 years ago, we had a vigorous discussion in the board governance committee about revising that particular policy. And the reason one of the reasons it was here is because this committee has jurisdiction over the board policy manual. So wherever we go on the personal trading policy, and Deborah Smith is taking a leading role in investments on that, it will ultimately result in a revision to the board policy manual. And so there is a role for the board governance committee to work with other committees to change the board policy manual and include that personal trading policy. So there is overlap in the work, but ultimately the jurisdiction over the board policy manual belongs to first the full board and then delegated to the board governance committee.
So who has responsibility then for a personal trading policy that would apply to the staff as opposed to the board?
Well, right now, that's a very good question. And right now, I think part of our discussion is to flesh that out and make recommendations. But right now, the personal trading policy that applies to the board and the insider trading policy that applies to the board and the entire organization is found in your board policy manual. So this was another subject I think we talked about a couple of years ago, and I think it's on our long-term to-do list, is to try to separate out from the board policy manual what are staff policies versus board policies. Right now, they're so interwoven that we think that would be an extensive effort. But we've talked to Amy about that. We think maybe down the road we might do that. But that's really where it is right now.
Okay, because I'm completely in favor of moving forward on updating and creating a more robust personal trading policy, both for the board and for the staff. I'm just trying to figure out whose responsibility is that, because Deborah's dealing with it to some degree in investments. We're dealing with it here. Tomorrow we're going to be talking about it at ARM because Dina's going to be talking about the work she's doing on the compliance side. So I'm just trying to, I'd just like us to figure out how we do it as in a coordinated way. I don't think we should be creating one set of policies for the board and a separate set of policies for the staff, or if we do, we should be doing it in a unified fashion where we're looking at it and making that decision. So I don't know whether this is something that needs to come back to the board leadership to figure out where this happens. But I get worried that if board governance is working on a little bit of it, and compliance is working on a little bit of it, and investments is working on a little bit of it, and we're not doing it in a coordinated fashion, we're not going to get there. So I'm completely in favor of doing it. I think it's long overdue. I just want to make sure we do it in an efficient way and figure out what that is.
Thank you. Mr. Juarez?
Yeah, so maybe it's just a matter of getting some clarification. I thought what we heard yesterday was along the lines of what Paul's talking about, is that through Deborah's efforts, there was going to be a coordinated effort, that we would be looking at the application to staff and then ultimately the application to the board for some personal trading policy. And I would assume, Paul, that the coordination would take place at the staff level, and again, how it works its way through the board is something I guess we can discuss, but I'm just assuming that that's where the coordination, because I could see where there might be slightly different rules for key staff versus board or versus the rest of staff.
Absolutely.
So it's not going to be sort of homogeneous that everybody's going to be subject to the same rule. So, but I leave that to staff to come to us and say, here's the appropriate division of application. And so unless I have it wrong, I'm assuming that's through Deborah and her staff.
Well, and Dina. I mean, that's,
Yeah,
I mean, I think that's
Right.
that's the.
Can you
that's
bring it
the-
back in?
sorry.
And that's what I'm trying to clarify. It seems to me that it, from what we're hearing, the people who are working on this are, and I don't want to say too much about our conversation yesterday because that was in closed session.
Okay.
But what I think I'm hearing is that Deborah's working on it. Dina, thank you for coming up, is working on it. Brian is working on it. You know, maybe we need something that comes back, and I'm not sure, you know, whether it comes back to board governance or ARM or the full board or investments, but it sounds to me like that's the team that's working on it and working on it in a coordinated way. Is that right?
That's right, yes, we are.
Okay, good.
They all shook
We're
their
all
heads.
not,
Good,
we're all nodding
good.
our heads,
That
but,
sounds,
I
that makes me
spoke up
happy,
first.
so good.
So maybe the direction is just, once again, to have the team coordinate and figure out which work plan this item should be added to for the next fiscal year in coordination
and
with the
working with
board
the-
leadership.
Yeah, working with the
That would
board.
be great.
and
Thank
committee
you,
leaders.
thank you.
Okay, great, thank you. We have I'm sorry, Ms. Higa.
I wanted to just go back to what we talked about just before this issue around you know, our policy on board education and the requirement for a certain number of hours within a 2-year period. I had forgotten or overlooked the fact that our, you know, education that we receive during board sessions like this one or our offsites applies toward that. And so I think Steve made a comment, but I just wanted to reinforce, if we could put in place some kind of something to help to make sure that we're tracking board member progress on that. I don't know when the 2-year period runs for each board member. I don't know, you know, I don't, and short of going back to every agenda and looking at what we've had, I don't know personally what I've done. I know what I've done in terms of offsite education, but I don't know how many hours I may have received from attending board meetings. So having something that would track it and help the board members identify where we are in the 2-year cycle would be helpful.
Sure, now I can certainly work with the executive office to create some sort of procedure, I suppose, and
you.
about how that will get monitored.
Mr. Keeley?
Thanks, Lynn. Just a thought, in thinking about the next couple of years, the faces around here will change dramatically. And to the extent we should be thinking about what, if anything, we want in a policy in terms of, for board education, so that new members who are joining the board get the appropriate amount and the quality, the types of educational opportunities that we think should be required, or maybe we don't believe it is necessary. But given the, I've been on the board now a while, and Dane, we get a really wide range of people coming onto the board with different skills, different backgrounds. So how we can make those transitions onto our board most successful, I think, is really the point, is to be thinking about that.
Okay, thank
If
you.
there's anything we need to do differently or have in a policy that we don't currently have, or maybe it's adequate.
Okay, thank you.
Sure.
Any other comments on the work plan? Okay. I think the next item is review of information requests, but I don't know that we have any, Mr. Brooks. Did you record any?
Well,
Aside from the work plan direction.
I'm glad you led with that, Ms. Paquin. So I had, yes, I was trying to encapsulate what we were just discussing, and I didn't know I kind of had maybe 3 potential requests for information. The request with respect to a way to track the board education hours in a 2-year cycle. I think what Ms. Higa and Mr. Wars were talking about, a request, and I think this coordination in terms of a board compliance policy, personal training policy, and then finally Mr. Keeley if we want any sort of information with respect to a policy for new members. But I don't know if you want those to be requests for informations or not.
Well, absolutely, yes. We do want to be requests for information, but I guess I was thinking of those more as committee direction, but I think we're on the same
Perfect.
page, so it's great.
Some of those, I think, were additions to the work plan. So,
Okay.
Okay. Item number 6 is the draft agenda for the November committee meeting. Any comments on that? No? And then we have opportunity for statement from the public. Is there anybody from the public who wish to make a comment at this time? Seeing none, we are adjourned. What time would you like to start the meeting, Madam President? 10 o'clock. Okay, thank you.